Hi. In the second clip on international environmental law, I'd like to introduce the two other important principles, namely the precautionary principle and the polluter pays principle. In the first clip, I addressed the question of the legal relevance and the legal basis of these kinds of general principles of environmental law, so check out this clip if you have questions on that aspect. The precautionary principle, also known as Rio Principle 15, is like the no harm principle, quite procedural in nature and therefore very much in tune with the overall theme of the procedural character of international environmental law. If we look at the Rio Declaration, what is written down or what is established regarding the precautionary principle is that, and I quote, "In order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation." As we can see here, the precautionary principle applies in a quite specific circumstance, and that is when there is scientific uncertainty regarding a particular question. So if we distinguish various sort of scenarios, on the one hand, we might of course have a lot of scientific data, a lot of knowledge regarding the potential impact of a certain policy, and in that case, of course, the precautionary principle does not come into play. You simply have a responsibility as a government to prevent harm that you know for certain will ensue from your actions. On the other hand, the scientific evidence might be more ambiguous, might be stating that it is not 100% certain that there will be a negative impact on the environment. And this is precisely when the precautionary principle comes into play, stating that even in such a case, governments, states need to err on the side of caution, as Klabbers said, and need to take steps to prevent any harm that might result, although we are not yet quite certain whether this will in fact be the case. Think, for example, of climate science about 30 or perhaps even 20 years ago, when it was considered probable, but not yet fully certain, that global warming was in fact caused and driven by man-made CO2 emissions. Well, the precautionary principle would have given us good guidance in this case. It would have told us that even though we are not certain, in order to prevent irreparable harm, CO2 emissions would need to be reduced anyways. And of course, by today, we know, the science knows, that global warming is driven by human actions. So how do you discharge this responsibility as a state? Well, above all, by doing more to overcome the scientific uncertainty and get a clear idea of how your policies would affect the environment. This means conducting environmental impact assessments. It means holding consultations with relevant stakeholders and making sure that these stakeholders are properly heard, that their participation is real and genuine, and that therefore all facts are being considered in order to establish whether a measure can in fact be taken safely or not. Next to these procedural obligations, there's also the substantive obligation to act on evidence that would call for a more precautionary approach. So if there is environmental damage and it afterwards turns out that the government knew or suspected that there was a risk involved in taking a certain step, well, then the precautionary approach, if established in an international instrument, could actually lead to international responsibility for that state. Who holds the burden of proof to show that a precautionary approach was necessary from an international legal standpoint? Well, it very much depends on the issue at stake and the instrument at stake, but usually this burden of proof will be on the claimant. And this, of course, was at stake in the pulp mills case between Argentina and Uruguay at the ICJ. And here the court found that in fact Argentina had proven that Uruguay had not taken all the necessary steps in line with the precautionary approach to in fact discharge this obligation that it had towards Argentina. Klabbers in the textbook chapter explains quite neatly why this is controversial and why it caused controversy even among the ICJ judges, but it is the way it is, particularly when it comes to substantive obligations, and this of course is why it is particularly important to keep in mind all these procedural obligations that I mentioned before, proving that there have not been enough environmental impact assessment, consultations and participation is easier, and in fact in some cases the burden of proof will actually then shift to the defendant, who then has to show to the court that all these steps were taken in line with the precautionary approach. The last principle that I'd like to introduce is the polluter pays principle. And Klabbers actually starts his discussion in the chapter by foregrounding the relevance of private actors such as companies, which count among the major polluters in the world. But then curiously, he does not actually return to the topic, thereby sidelining the polluter pays principle, which is among the most important principles when it comes to giving effect to international environmental agreements. As with the other two principles, I'd like to read out the relevant provision, in this case in the Rio Declaration, which is also why the polluter pays principle is known as Rio Principle 16. And this provision states that, and I quote, national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account the approach that the polluter should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. This is quite a mouthful, but let's start with the basic but really important insight because it's a mistake that is often made. The polluter in this case refers to companies, to actors operating within the jurisdiction of a state, not to the state itself. And this might be counterintuitive because you might think, okay, polluter pays principle probably suggests that state A, when it pollutes something and it has an impact on a state B, should then compensate state B. And this might be the case under the law of state responsibility and, for example, considering the no harm principle. But in this case, when it comes to the polluter pays principle, the polluter is not the state, and the obligation that we have here is actually to make sure that the polluting private parties will in fact bear the costs of the pollution, of the environmental damage that they cause. The provision mentions the internalization of environmental costs, and this is just fancy language for basically saying the same thing. For saying that the state, national authorities should make sure, notably through enacting legislation, that private actors, that companies will incorporate the costs, the damages of environmental harm into the price of their products and into the structure of their companies. Different ways exist to implement the polluter pays principle, but how states usually go about it is by creating civil liability. So if a private actor, if a company causes environmental damage that then leads to a breach of an international legal obligation, then this company will be held financially liable for this damage. And this, of course, is also meant to act as an incentive for companies to avoid harming the environment and potentially even proactively protecting the environment. Now, there's an important and quite obvious qualification towards the end of this provision, which is that states can, in principle, balance the polluter pays principle against the public interest, but also against international trade and investment law. And this, of course, is the heed that not just international environmental law pays to other fields of law, but also to economic interests more generally, with, of course, a real risk of undermining the protective effect that this principle is supposed to have. The fact that polluting private parties might get away with not paying for the environmental damage that they have created is, of course, regrettable, but it is also a reminder that there are political dynamics at stake here that do not always prioritize the environment, and this, of course, is a story that we know all too well, not least from the climate crisis discussions. As already stated in the first clip, international environmental law is a very rich domain that I could go on discussing for hours, but I'll leave it at this, and I'll refer you to Klabbers' textbook chapter, as he makes a good effort to introduce all the various instruments pertaining to different issues. I look forward to discussing these and questions that you might have during the live session. See you then.